All right. We're going to get started again. I don't have a gavel, but bring this session to order. All right, so now we're going to pick up where we left off from the two previous sessions where we had non-judges, and we have two very experienced and very distinguished judges to try to tie these threads together. And there are a lot of threads, and I plead guilty to leaving a whole host of threads hanging in the last panel. But the two judges we have this morning are really just great people to have, and we're very delighted that they decided to join us. Over on the left is Judge Brock Hornby from the District of Maine. He's a district judge there, and he has been for 25 years. But before that, he had at least two other relevant careers. He was on the Maine Supreme Court, so he's served on the judge of the highest court of one of the states, and he was a law professor at the University of Virginia. So he's just a great asset to the federal judiciary, and we're very glad that Brock has joined us. And then next to me is Judge Janice Rogers Brown from the D.C. Circuit Court of Appeal. And she's had a very distinguished career on that court. And prior to that, she was a judge of the California Supreme Court and the California Court of Appeal. So she also had the experience of serving on the highest court of a state. And we will talk some about federalism and the interplay between the state and the federal courts as a result of Reconstruction. But I could not think of two judges I'd rather have up here with me, and so thank you both for being here. And let me just ask a real simple question. When you think about your judicial career, how have the Reconstruction amendments played a role in it? How have they affected the arc of your career, both as state appellate judges and as federal judges? I'll start with Judge Brown. Yeah.
Well, I think I should start by saying that it sounds odd, perhaps, to say how have the Reconstruction amendments affected your career, because that was a long time ago, and I think I should acknowledge that I think much has changed, and the circumstances that the Reconstruction Congress faced are obviously not the same problems that we're dealing with today. And the problems that they were trying to solve have largely been solved. We are thankfully no longer dealing with de jure segregation or laws that intentionally try to put a particular race in a position of inferiority. There's very little overtly racial legislation or classification, unless you're talking about what came up in the earlier panel, racial preferences or that sort of thing. If it's being done now, it's at least being done and justified as being beneficial to the group that's being singled out. So in another way, our consideration of the Reconstruction amendments is kind of ubiquitous because equal protection due process is in just about every case. And because of, again, what happened with the Privileges and Immunities Clause, that has had to carry, equal protection and due process has had to carry a lot more constitutional weight than perhaps was ever intended. And that's why we fight pretty viciously over what those things mean. There's a lot of scholarship about what exactly does that mean? And it's possible, as you've heard earlier, that some of the reason that we're fighting over substantive due process is because we don't have privileges and immunities. So there's lots of ways in which all of this connects. But I assumed that your question is really not so much about those run-of-the-mill cases, but more about the cases that specifically might implicate those amendments. So I'm on the DC Circuit, and the DC Circuit actually still has a role to play in Section 5 clearance cases of the Voting Rights Act, which is a direct has a direct tie to the Reconstruction amendments. And so that's still part of our portfolio on that court. And who knows, after Shelby County, I don't know if you are familiar with Shelby County, but that's a Voting Rights Act case that's quite recent. And it probably will change how those pre-clearance cases look. But that's something that's still, part of our contemporary jurisprudence that comes directly from the Reconstruction amendments. But I just tried to think, what cases could I think of in the last 20 years that have sort of talked about the Reconstruction or this idea of equality specifically? Because now we're not really looking at racial classification. And so one case that I pulled, I just thought was kind of interesting. This is a case when I was on the California Supreme Court where a young man was ticketed for riding a bicycle the wrong way on a sidewalk. And because he was ticketed, basically because he committed that infraction, he could then be asked for his identification, which he didn't have, which meant that he could be arrested. And if he could be arrested, that meant he could be searched. And when he was searched, they found drugs. And so he ended up in prison. This all started from riding a bicycle the wrong way. So one of the things that I say in this case, and at the time, I did not know his ethnic background. So I say in the case, I don't know Mr. McKay's ethnic background. One thing I would bet on, he was not riding his bike a few doors down from his home in Bel Air or Brentwood or Rancho Palos Verdes, places where no resident would be arrested for riding the wrong way on a bicycle, whether he had his driver's license or not. Well, he would not get arrested unless he looked like he did not belong in the neighborhood. That is the problem, and it matters. The rule of law implies equality and justice in its application. If we are committed to a rule of law that applies equally to minorities as well as majorities, to the poor as well as the rich, we cannot countenance standards that permit and encourage discriminatory enforcement. So my point is, this is not exactly like the Reconstruction amendments, but there's a theme that runs through those amendments, which is equality before the law, right? Mm-hmm. And so, as a judge now, you can see that maybe certain things don't work exactly the way you would want them to work. When I first came to the DC Circuit, one of the first things that I encountered was something that happens there, with some frequency. The police use something they call jump out cars. And they will often just stop people. And in this particular case, the basis for the stop was, we had a lookout that there was a suspect running away from a stolen car. He was described as a black male between 5'8" and 5'10", wearing a dark jacket and jeans. Now, this is a neighborhood that is primarily African American, and so that description probably fit 80% of the people that you would see in that neighborhood. The police, though, stopped, or didn't stop, decided to question 4 men who were standing at a service station, one of whom was 6'4". They told all of them they couldn't leave. And so, of course, once they had a reason to search people, what they found was that one of them, one of the 4, had drugs. And so the case comes to us on a suppression motion, but, and I lost the argument there. And so I'm writing in dissent here. But I said, the first inappropriate use of Terry in America's minority neighborhoods offends the principle of equal justice under law. For, as we all know, courts would not approve the search of 4 men in business attire conversing peaceably in front of a Starbucks if the only basis for the search was a lookout broadcast specifying a white man, medium height and build, wearing a business suit. Okay? I mean, so recognition that you don't have to ignore what is obvious, what is in front of you, that you know what's going on. So just some examples of how you might see that used.
Right, and this is a whole field of study called social context. You know, it's like where does something happen? So, Brock, anyone want to?
Well, I endorse all of what Judge Brown has said. We still get occasional equal protection challenges to state employment practices. I'm aware of one case pending in our court right now. It's not my case, but where an African-American woman is challenging her treatment by the state prison as an employee. So there are still some of the classic cases, although not as many as there would have been years ago. But I want to turn a little bit to what I think Judge Brown called the run-of-the-mill cases. We are hugely affected by the due process clause and the incorporation clause in a lot of ways. As a state judge, I knew, for example, that the 14th Amendment due process clause controlled criminal trial procedures in the state of Maine. The deprivation of life or liberty without due process of law directly confronts the state courts. And then in addition, by the doctrine of incorporation, you bring in MAP against Ohio, searches and seizures. You bring in Miranda against Arizona with respect to the Fifth Amendment and confessions. Gideon versus Wainwright, the Sixth Amendment, right to counsel. So there is a huge impact, certainly, on state courts, even in today's world. On the federal side, less, because the 14th Amendment does not apply to the federal courts. We're dealing, of course, with the Fifth Amendment, not with the 14th Amendment. But then turning back to the civil side, if you think again about the incorporation part of the 14th Amendment, that means, for example, that we have First Amendment issues coming into what state governments do. We've had challenges in Maine and Massachusetts to local panhandling ordinances, panhandling on the medians. You have issues involving school cafeterias, whether they have to be open to religious organizations, if they're open to others, public forum kind of cases. I've had a whole bunch of election cases in Maine where there are challenges brought to the state elections laws based on First Amendment issues, whether independent candidates are treated equally to party candidates, whether the Maine clean election law is constitutional or not under the First Amendment. So I think that if you go and look at the larger scope, particularly because of incorporation, it continues to have a huge impact in terms of the decisions that state and federal judges make. I want to draw one contrast, perhaps, between what a circuit judge like Judge Brown would do and what I, as a district judge, might do. There was talk in some of the earlier panels about being in the weeds. Well, that's what district judges are. We're in the weeds. And so this glorious history, which I've just really reveled in listening to the panels today and reading the readings, we don't often get to that as district judges. Instead, what we get with is this strict scrutiny, or is it rational basis review, or is it intermediate scrutiny? Is this a class of one? Is there a property interest here that's protected by the due process clause? If so, is it a pre or post deprivation hearing? It's not at the level that we're talking about the district judges have to do with it. It's good to be reminded of what is behind.
Absolutely. And this actually anticipates, so your experience, Judge Brown, as an appellate judge, I mean, do you feel like you get a chance to look at these larger historical issues as often as you'd like?
Not nearly as much as I would like to do. But I'm a wonk, so I love all of this kind of thing, and I would love to do more of it. But of course, all this historical research would interfere with my day job, so I don't get to do it.
Well, but you know, this really leads to another question, which is, so the reason we've talked about this history is this is the context in which we are doing our work, right? I mean, we've got these amendments that were adopted 150 years ago. We've heard from the historians it wasn't quite as high-minded as all that. You know, it was not one of the terms that's used for that period is the second founding, and I think we can talk about whether that's accurate or not. But certainly there were some ideals. We just abolished slavery, and we were trying to have a better society. And so what happened during that 150 years is not so pretty. I mean, when you're doing your jobs as judges, I mean, has that affected you in your daily life and the decisions that you make and the way you approach the issues that are presented to you, that history. And Brock, I'm going to start with you because you actually shared with me that even before you became a practicing lawyer, back in your law clerk days, you had to think about this.
What Jeremy's referring to
Yeah.
is that when I graduated from law school in 1969, I went down to the old Fifth Circuit to clerk for John Minor Wisdom on the U.S. Court of Appeals in New Orleans. I think I arrived in August. In October, the Supreme Court announced in Alexander versus Holmes County that the time for all deliberate speed had come to an end, that desegregation had to occur now. Those of you who are younger here may not realize that Brown was decided in 54, but the remedy was put off until 55, and the all deliberate speed was used as a great basis for delay in many of the southern states. The Justice Department had been pushing and providing plans for desegregation, and then in the new Nixon administration, it was concluded that the plan, at least for Mississippi, was too ambitious, couldn't be done, and so Robert Finch, the Secretary of Health, Education, and Welfare, hand-carried a letter down to the Fifth Circuit asking that it be delayed, and they delayed it, and then it was appealed by the NAACP Legal Defense Fund, Jack Greenberg, to the Supreme Court. Most people believe that Justice Black wrote the per curiam decision, but it said, it's over. Now you must desegregate. I remember sitting in the old Fifth Circuit courtroom watching Griffin Bell, who was then on the Fifth Circuit. He went on to be Attorney General under Jimmy Carter. But he was there with the panel, there were three, and in the courtroom were all the school superintendents and lawyers from Mississippi, and they were saying, we can't get buses, we can't do it quick enough. And I remember Griffin Bell said, it says now. And so that was my introduction to the 14th Amendment and and the way it's applied as going forward. But your question was, how has it affected us in terms, I think you're saying, of the lapse in terms of its enforcement over the years? That's a hard one again for me as a district judge, because as a district judge, I'm not a politician in robes. I try to do whatever the circuit says and whatever the Supreme Court says, and so my attention is really focused on what is the latest that's been said by the Court of Appeals or by the Supreme Court. And so what has happened in the past has less impact on me in that respect. But at a conceptual level, it certainly does teach me to be modest about what we think we know as judges when we're interpreting the Constitution. It teaches me to be modest about what we even think we know about history. I mean, just listening to the historians here this morning or reading what they've said, it's an evolving understanding, and perhaps will never be finally decided. Revisionism is always occurring in history. And so somebody said that the way our Constitution is implemented here is a great experiment, and I think it is when you think of it, that we're taking words that were put together 150 years ago or 225 years ago and trying to figure out what they mean now. It's almost like Talmudic scholars dealing with the Torah in terms of the change and understanding what the words meant. I don't think we've got it right yet, and we probably never will. So it does make me be modest.
Yeah. You want to take that one on too?
Yeah, I guess when you ask, how has that affected me? Does it affect my perspective? And, my response was, well, how could it not, right? A couple of years ago, a friend of mine who does a program for college students trying to teach them principles of the American founding had her assistant call me, and she said, it's February, it's Black History Month, we would love for you to come down, and she particularly wants you because she wants somebody who can speak from experience. So I was a little bit miffed. I said, are you trying to say I'm a historical relic? I'm so old that I can speak from experience. So I thought about that a while, and I thought, in a way, I am a relic of another age because I am old enough to remember when Brown was decided. I remember de jure segregation. I went to segregated schools when I was young. My grandparents were very involved in the civic clubs and voter registration and all of that stuff. So this was not ancient history. It was really life, So yes, it has affected my perspective and my worldview. One of the things, this conversation that's going back and forth about, well, what did judges do and why did they do it and what were they actually trying to get at? And I think one of the things that long delay taught me was, one, that no matter how stirring the words, no matter how clever the verbal formulations or sincere the intentions, unless the people are committed to the philosophical meta-narrative, it's just, words are not enough.
Yeah.
And so I agree with Judge Hornby that, one of the things that's required is humility. That is not hubris, not assuming that what you think is the way things ought to be, but another thing that's required is courage. And so one of the things that I feel when I look at this history that perhaps judges failed to do was to show that courage, because these words were right there. The nation had been through this searing, unbelievable, horrific civil war. There had been great sacrifices made. And what the Republicans, the radical Republicans at least, were trying to do was to finish the founding. I don't think of it as a second founding. I think they were just trying to finish what they started, which is, if you believe that all men are created equal and they have inalienable rights, then how do you effectuate that for these people who have been enslaved? But when it got to the courts, they backed off of that. They turned that around. They came up with very crabbed and weird constructions of words that were pretty straightforward, that were pretty clear. So I understand that the historians are able to get into this much more deeply than I have been able to do. And I agree with them that you can find evidence for whatever you want to find evidence for. And we being Homo sapiens, thinking creatures, we can rationalize whatever we want to do. And so there's always some inconclusiveness to what's happening. But I think if you look at what they said about what they were trying to do, if you look at the history of the country, if you look at the telos of the American founding, which is natural rights, natural law, and you see that thread come right through, clearly expressed by the Reconstruction Congress, you could have figured out where they were trying to go. It wouldn't have been perfect. You wouldn't have done all of these things. Maybe you wouldn't have had the political rights right away, but then they passed the 15th Amendment. So it looked pretty clear. And what it makes me wonder is, would things have been different? Would we have had to wait 100 years for the final chapter of this if the courts had, in fact, just interpreted the amendments in a straightforward way?
Right. So if back to where we started earlier this morning, I mean, if slaughterhouse had been decided differently.
It might have been a completely different story.
But yes, go ahead.
If I could just add on to what Judge Brown says, exactly right about the lack of courage during that early period, but just as a kind of counterpoint to that, fortunately there was some courage after Brown, and there were some judges in the Deep South, Frank Johnson, Northern Skelly Wright in New Orleans before he went to the D.C. Circuit, where you are now, where they really exhibited courage in trying to make sure that Brown was enforced over physical threats and otherwise.
Right.
Yes.
That's right.
And this was not easy, and I say amen to that. Judge Johnson's one of my personal heroes, because what one of the historians said was, well, courts do not lead. They're not out there as change agents. They tend to do what public polling, what public opinion kind of says they should do. And to some extent that's true. I mean, we're all products of the community and the environment in which we live. There's no question about that. But one of the reasons we finally got the Voting Rights Act was because the Department of Justice was there in Alabama and Mississippi and all these places year after year after year. They brought case after case after case. And, they just kept moving the goalpost. Yeah. They could never make that stick. And there were some judges who basically didn't want to rock the boat, didn't want to do anything that would offend their neighbors, but there were others who got right out there, and whatever it took, they did it. And they followed up, and they kept pushing. Now, it finally took a legislative enactment, but what they did was amazing.
Mm-hmm. Well, the King movie really describes that history very well. Professor Kennedy was saying that his view, I mean, I asked him sort of a leading question, but that you have to see Plessy as sort of a reflective of the social mores of the time, the culture in which it was decided, and the Supreme Court just wasn't ready to go there, at least a majority of them were not. Do you think that that's a fair assessment of how change tends to happen, that you have these there's always the Frank Johnsons and the Skelly Wrights who will be brave, but that in general the judiciary tends to be more small c conservative in that respect?
Yeah. Well, I was going to say the judiciary's role is to be conservative. In fact, you know, Tocqueville talks about this and says, you know, the ways and tastes of magistrates are a good thing because it keeps us from going off the deep end. So it's part of what we do. We have a constrained role. On the other hand, you know, if Congress acts and what Congress is doing is not unconstitutional, right? And in this case, it would be hard for it to be because they were changing the Constitution, right? So, you know, so it wasn't like the judges would be out on a limb, you know, leading the people where they did not wish to go. But now we had the complication of this was at the end of a war. We had a South that was, you know, defeated, I guess, but not conquered, not really too concerned about loyalty or allegiance to the Constitution and that sort of thing. So there was this effort of reconciliation going on. The Congress seemed to have been willing to push past that. The courts seemed unwilling to back them up.
So let's fast forward. We ended the last session talking a little bit about contemporary debates. What can we learn from this history we've been talking about? I mean, we're dealing with, still dealing with issues around affirmative action and preferences. It's before the Supreme Court this term again. We have very loud and serious public debate about policing, the legitimacy of our law enforcement agencies. What can we learn from this history as judges? And how can we have, I mean, the second part of the question really, how can we have a constructive conversation about it?
Oh,
yeah, go ahead.
I thought we were.
You're on a roll.
I'm looking at both of you, so I don't care at this point.
Okay.
Yeah.
Well, I guess my sense of this is that I look at the Reconstruction Amendment sort of the same way that I look at the Declaration of Independence and you know, other parts of the founding conversation, which is to say, you know, it's a background consideration. It's a conception of fairness in the way we do things. We know that they were all about equality. I think we also know that you know, there was a concern with fairness in in fact, one of our readings had, and I think Professor Harrison was here, was a fascinating discussion of protection of the laws, which we've sort of undermined, but the way that he was discussing it was fascinating because protection of the laws, I think, would play into just the kinds of things that I was talking about earlier when I was looking at some of the decisions that we've had. You know, are you doing that in a way that it is actually equal, right? So I can see many ways in which we could kind of look at that and find ourselves looking at things that we're doing. For instance, one thing that's you might be aware of that's just come up is the Congress very recently enacted a bill to get rid of the crack cocaine powder sentencing disparity. I don't know if how many other people are dealing with that, but that conversation went on for 20 years, right? And it took them 20 years to decide that 100-to-1 disparity, which almost always worked to the disadvantage of minorities who got, because they are the ones who sell crack, was something that they should be concerned about. Now, the interesting thing about that, I will say, is that the reason for the disparity in the first place was because the community asked for it. So they were not being bigoted in coming up with that. They had responded to concerns of the community that was a plague that was causing many very serious problems for them, and they wanted huge deterrence. And so that's what they did. But how that worked out was that people who were caught on the lower end of crack sales were spending much more time in prison. It also meant that there was a much more pervasive police presence in those communities because you had those open drug bazaars and so forth. So there's all kinds of ways in which, this is still kind of playing out.
We're still figuring it out, and there are unintended consequences from
And
things.
sentencing is the one place where trial judges really do get into it. And as Judge Brown has talked about, it was the Len Bias case that provoked the 100-to-1 ratio, which over time has been corrected to some degree. But when sentencing guidelines first came in, one of their purposes was to try to avoid disparities among judges, including disparities that might be conscious or implicit race bias as to how they were implemented. The irony is that we learned that institutionally we then incorporated bias, not just through the crack to cocaine, but the whole criminal history calculation. If young African American males are being arrested more and given to small crimes, then it adds up and affects in that respect. Now we have the Booker decision that makes guidelines advisory, and the empirical data is giving a little bit of cause for concern that maybe some of the bias will be creeping back in terms of what takes place. So it's an ongoing work in progress. We always have to struggle and be very conscious of what we're doing. And I think that's what I would say in the trial court level, what we trial judges have to do in respect to the Reconstruction amendments and the search for equality is to be aware of everything we do in the courtroom is measured against that. It includes who our deputy marshals are in the courtroom, who our staff are, the way we treat witnesses, the way we treat jurors. It's an incremental process, day by day, in terms of what we do. We don't get to make the broader decisions that maybe the circuit judges do or the Supreme Court does. We can't deal with police brutality directly. Where we get it, of course, is a motion to suppress, or we get it on a 1983 lawsuit where there's a defense of qualified immunity that will come in. But my conclusion is that we simply have to do it day by day of everything we do to make sure that we try to live up to what the Reconstruction Amendment stood for.
And how do we do that? I mean, obviously there's the intention that you talked about, and I think that's absolutely essential. But how do we, and this is something I'm really trying to think about, as you know, just in terms of education, how do we get a hold of those things? How do we know what we don't know? If you're self-reflective, you can say, yeah, well, I actually don't like this kind of person, or I have these feelings because of things in my background. But that's the easy stuff. That's actually the low-hanging fruit. The stuff that's hard to get to is the stuff you just don't see. So any thoughts about that? I mean, is that something that enters into your thought process about it?
Well, there are education programs about that teach sensitivity in terms of being awareness, and I think those are useful and valuable, particularly for judges from Maine or North Dakota that maybe aren't as exposed to a variety of people as other judges are. But beyond that, I think it's treating every person with dignity. Every person that comes in with dignity is the major measure, I think, in terms of going forward. And here's an example. So we, over time, have had immigrant communities come into the state of Maine, and most recently we had a large Somali presence. And so when I have a Somali defendant and the Somali elders come into court, I take the interpreter and have the interpreter turn around and speak to the entire courtroom so that they understand as well what's going on. Somebody suggested that to me. It wouldn't have occurred to me, but somebody suggested you can be more cognizant of and more respectful of that community if you make sure that everybody out there in the courtroom can hear what's being said and be translated. So I think it has a matter of just being sensitive to some of those things.
thoughts about this?
Well, first let me applaud what Judge Hornby is saying. I have never been a trial judge, and so that question about how trial judges might do this isn't one that I can speak to very directly, but I do know that the cases that come up to me when those suppression motions get denied, you know, and you're sometimes looking at them, and you can see that, you know, those judges are doing the same thing that the judges on my court will do, which is to look at some precedent and to say, well, boy, this looks bad. It's really kind of shady, but what can I do, right? And so, Terry stops are one of the things that really makes me a little bit crazy, because they get segmented in a way that just allows you look at one part. Well, when they stop them, we say, that was just a citizen police interaction. But then after they were stopped, the police say they looked nervous. And so, and you know, and that rolls on into some kind of articulable suspicion. So I agree with him that one of the things that courts have to do is just, you know, look at things realistically, try to figure out what is really going on, you know, try to think through how things really work in a practical sense. And, you know, don't pass over it at 30,000 feet. You know, get in there and think about what's going on and how that plays out and how that really works, because you're dealing with real people who are suffering the consequences of you know, those interactions. And I think it's good for everybody and I'm not criticizing the police. I think they have a very difficult job. I want to be very clear about that when I say they shouldn't be given unfettered discretion, when I say that, you know, sometimes they play the numbers and they take advantage of being where they are. That's true. But many of the police that I'm dealing with, particularly in DC, are also members of minority groups. So they are not, you know, they are just, there is a metric for every organization and institution. You have to show that you're effective. And for police, being effective is arresting people. And that's kind of what happens. But, you know, when courts are looking at that, they have to look at what's going on with these processes and procedures. Are they being equally applied? Are they fair?
Well, how do we, you know, this sort of gets into something that's been, I guess, has been kind of obsessing me lately, which is that there are, we sort of have soundbite type debates about these kinds of things. You know, police good, police bad, yeah. You know, affirmative action good, affirmative action bad, and that we don't really have the space, particularly as judges, because we're busy doing our cases, to learn, you know, to have sort of critical discussion about, well, what is actually going on. You know, we can certainly relate to things that are familiar to us from our life experience, but right. You know, what if something is completely unfamiliar to us, and story may seem plausible to one person, completely implausible to another person because they haven't had any experience with that. So how do we develop the ability for intellectual openness and inquiry when we're trying to decide these hard cases every day?
Well, I think a program like this is a great example where you have given us readings and presentations that I would not in my work life have come across. These things aren't argued to me at this level when I confront a motion to suppress or when I confront a case involving a public school cafeteria. But beyond that, I think we could probably take more steps. When I was on the state Supreme Court, we as judges would meet with police officers at our part of our continuing education session to learn about some of the things they were confronting. Maybe that's something the Federal Judicial Center could consider doing, of having some interchange with the various constituencies where we'd learn more, just like I mentioned earlier, maybe some sensitivity training for judges. I think we can always be taught more. We have to keep learning all the time. And so I think a program like this is one way.
Oh, I totally agree with that. I love programs like this. I mean, it's nice to have the Supreme Court review and, you know, how to do scientific evidence and what do all the what is the next thing in neuroscience?
Neuroscience, yeah.
That's what I've been
That's
hearing
the
at every
magic pill
place
that's
that
going to
we
make it
have been going.
unnecessary for us to make decisions.
Exactly. So all of that is well and good, but we, this is our stock in trade. We need to understand our history. We need to know why things happened, how they happened, because, one of the things that has occurred to me throughout all of this reading is if the judges involved here weren't just being political, right? If we give them the benefit of the doubt, if they'd just done a better job of figuring out what was really going on, we might have had some different and better results from that. So I love the idea of programs like this. I think they're a benefit to everybody. But I want to say another thing that I think is really kind of simple, and it's certainly something that circuit court judges get to do. I don't know if trial court judges can do it. But one of the benefits that you have is your colleagues. You may not have had those experiences, but they have, right? Take advantage of the fact that there is diversity among the population of judges. Have conversations with them. One thing that circuit court judges can do is we can talk about the actual case that's before us. And we can say to somebody, really? I doubt it.
Wasn't like that in my neighborhood.
Yeah, exactly. So you can have that conversation, and those conversations, may benefit you just in getting a sense of how things work in the real world. Now, what was funny about the case that I read to you, Goddard, I lost the argument there. I said we should have drawn a line and said you cannot say that a description that general is a basis of articulable suspicion. And my colleague said, oh, yeah, right. And they didn't agree with me. But what they wrote was a per curiam decision, because they were kind of embarrassed.
Yeah.
And then the author of that decision actually wrote a concurrence saying, well, if my hands weren't tied by precedent, I would have done otherwise. And so what I have said to my fellow judges is, if our hands are really tied, we need to gnaw through the ropes. Let's pay attention to what's going on.
This actually is a perfect segue to a question we got from the audience.
Okay.
Which has to do with, Judge Hornby was talking about modesty, which I think is a critical trait for all judges, and
totally.
we all need to work at that. But the other side of that is courage. When is the time for courage? How do you know? I mean, how do you know that this is the case where I'm not going to be modest and I'm going to really stick my neck out and make a statement? And it's different for district and circuit judges. So I'm going to start at the district court level. I've read about Frank Johnson, and he was a courageous person in many, many respects, and he came from a long line of courageous people. But when do you know, and when do you say, I'm standing my ground here?
Well, I think that when the law is clear and the question is enforcement of it, that's an easy case for a district judge. Your obligation is to be courageous there, to take the community opprobrium, the May result or whatever, and to go ahead and apply the law. That's what Frank Johnson was doing. That's what Skelly Wright was doing. I think where it's more difficult is where the law is unclear, because then you have institutional rules. And so if the First Circuit hasn't spoken directly to the issue, but there's dictum that indicates where they'd go, I feel obliged to follow that dictum and not be courageous by saying, they're crazy, I want to go this way. So I think it depends on the nature of the case. For a trial judge, if the law is open, you can be courageous in moving forward in terms of a decision that needs to be made because of first principles, like the First Amendment or the 14th or whatever. But if the law is set by the Supreme Court or by the First Circuit, I don't think that's courage. I think that's being institutionally irresponsible in terms of what you do.
So you do have to defer to the rules of engagement.
I think it's our obligation.
Yeah.
This is, I think that's what is sort of determinative, is that in a regime where you care about the rule of law, you play by the rules. To me, courage means doing the right thing. And so that, if the law is clear, then to back away from that because people won't love you, is not the right thing to do. Unfortunately, this is a job which you probably shouldn't take if you wish to be loved, because somebody's going to be unhappy with just about everything that you ever do. But so I agree. I totally agree about humility. I think it is, sometimes difficult to know when to do something, and you always, I call it, in California, we used to call it swimming in the jaws of the crocodile, because you're always, you're an intermediate court, and so the Supreme Court can always say something different. But even though you have to play by the rules, nothing prohibits you from saying, I'm doing this, but they're dragging me kicking and screaming, and here's why.
So you can still speak up.
You can still speak up.
Yeah. So we have one last question, and I don't mean it to be sort of an afterthought, but it actually, we've been talking about the Reconstruction amendments in terms of racial relations and our history in that area. But we had a question from the audience about women. And there was mention back in the very beginning that the amendments very consciously were intended to empower men who had been slaves, and very conspicuously did not empower women, whether they'd been slaves or not. Do we need an equal rights amendment? And I'm not asking you for judicial opinion. I'm just sort of asking in terms of the way that our society has evolved. Can we find in the way the amendments are applied today the legal framework for equality on the basis of sex?
I think one of the things that we maybe haven't talked about this morning is how the Reconstruction amendments have infused our statutory law. And so now we have, for example, Title VII, we have state human rights acts, we have all kinds of laws that have been passed that I think do provide, because of the Reconstruction amendments. Those laws probably wouldn't have come into effect without that. So I would look to that and say there are an awful lot of remedies out there. I don't know if an equal rights amendment is even on top of those. I don't have an opinion on that.
Yeah, I think I agree with Judge Hornby that we probably don't need it. But that discussion at least began with the Reconstruction amendments, and perhaps even because there was so much lag time and because we had to rely on equal protection, I think that argument for women got easier in a sense.
Because we couldn't rely on privileges and
Exactly.
immunities, and so equal protection and substantive due process, which doesn't appear anywhere in the Constitution, have carried a lot of water.
That's exactly right.
So I think we are out of time. Please join me in thanking Judge Hornby and Judge Rogers Brown.
So this is the, no, thank you, you did good.
You're still on your mic.